Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 72, we're going to dig a little bit into the CARES Act just because we're in a situation where Congress has now adjourned until post-election and it doesn't look like they're going to get any sort of further coronavirus-related relief passed prior to November 6th or when they re-adjourn. So I thought it would be helpful today for us to discuss what can you do if you don't have access anymore to COVID-related benefits like unemployment or any of the special hardship payments they were making. And one thing that was publicized at the time but not widely talked about was the fact that you can take, if you have access to an IRA or qualified plan, you can take hardship distributions or disaster-related distributions from that IRA or qualified plan. And we'll look at the form, which is in draft form for reporting these right now, and that's Form 8915-E. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, what the CARES Act allows for is distributions from an IRA or a qualified retirement plan if you are a qualified individual who's affected by COVID. So the definition of qualified individual is fairly broad-reaching. First, it's if you or your spouse have had a CDC-approved positive test, it appears that you could be a qualified individual. Now, the way the law words it is that it's a diagnosis of COVID, but right now it looks like a positive test from a medical provider could probably meet that requirement unless it's a fly-by-night type of pay for the test pop-up type of operation. Now, interestingly, you don't have to have had adverse financial consequences if you have a positive test. But if you don't have any positive test, you get into the question of whether you've experienced adverse financial consequences due to COVID. And they call out three areas where you can. One is just being laid off, furloughed, or having your hours reduced due to COVID and or being quarantined. A second category is where you have an inability to work, mainly due to lack of child care related to COVID, or if you're a business owner, the third category would be a situation where you've had to close or reduce your hours of business that you own for a business that you own or operate due to COVID. So, there's no other qualifier for any of these, and you don't have to substantiate the amount of the distribution or show how much you've been affected. Instead, there's just a total cap for 2020 that caps the distribution at $100,000 across all qualified plans and IRAs. Now, when you take the withdrawal, importantly, you don't have to be age 59 and a half. This is an early withdrawal, so there's no 10% penalty that applies. And it is taxable, but there's some nuance to that. One is that you can divide your distribution in 2020 into thirds. You can tax it ratably over 2020, 2021, and 2022 and have 1/3 taxed in each of those years, or you can elect to have it all taxed in 2020. Also, you have the ability, if you come into money, to refund any of these advanced IRA or qualified plan distributions. You can refund up to 3 years from the date of first distribution, and obviously that's going to decrease the amount that you're taxable on, and we'll look at the ordering rules for that here in a few slides, but for the time being that's a helpful piece to realize that this is kind of equivalent to a rollover, but more in the nature of having 3 years instead of just 60 days. Now, if you do refund a previously taxed distribution, what you're going to have to do is go back and file an amended return for 2020 and or 2021. Now, the rules for this, we luckily have some guidance because they're largely modeled off of the procedures and examples that came from IRS Notice 2005-92, and that dealt with Katrina related IRA hardship distributions, the KETRA distributions from way back in 2005, which it's hard to believe was 15 years ago, but that guidance still holds true today and provides guidance for the COVID-related distributions. Now, one important piece that's not in any of the CARES Act guidance that I pulled from this IRS notice is that these distributions should not be treated as a change to any existing Section 72T4 substantially equal payments. So if you have started taking early IRA distributions under that substantially equal standard, if you choose to take a COVID-related distribution, it won't mess that up. As long as you continue to take those substantially equal payments, it won't be a change to those. Now, as I mentioned, the form for this is still in draft form, but you report this on IRS Form 8915E. Now, a lot of you may not have filed previously for disaster-related withdrawals, and there are forms for 2018 and 2019 with the same naming class, Forms 8915C and 8915D. If you have any of those have to wrap over into Form 8915E as well, and that kind of skews the calculations, but we're going to assume that you have none of those, and even though the form is in draft form right now, it is available out there for you to look at, and it provides for elections by category, first on qualified retirement plan distributions and then on IRA distributions. So, as I mentioned earlier, you can tax this over 3 years, or you have the ability to elect to have it all taxable in 2020 if you take the distribution. And what the form seems to indicate is that you can make these elections on 3-year versus immediate separately for qualified retirement plan distributions versus IRA distributions. And if you're making refunds, as we're about to see, the standard for refunds, as it is with any sort of a rollover or other types of a overdraw or overpayment into an IRA, is that you have up until your filing deadline or your actual date of filing to count that refund against your taxable income. So you can net that here. Even if you're filing in 2021, you can make a refund and count that as an offset against the amount that's taxable for 2020. And then the taxable amount from that form, once you've netted out refunds, will carry over to Form 1040 to the lines dealing with the taxable portion of the IRA or qualified plan distributions. Now, if you do elect 3-year tax deferral, it is a little tricky to look at the refund calculation. I guess first off, if you'd done 1 year, then obviously a later refund, the 1-year election doesn't necessarily affect your ability to refund within 3 years, so you would have to go back and amend your returns. But if you are on the 3-year tax deferral, then the refund will first reduce the amount that's included in your taxable income for the tax filing year of repayment. So if you're doing a refund on the 2021 return, then you're going to reduce the taxable amount for 2021. And if you have any excess, you have the choice to either carry that forward to the taxable third of the next year's distribution or carry it back to the taxable third of the prior year's distribution with an amended return, or both. It's really at the election of the taxpayer. And that's not a hard and fast rule. It's more just based on examples set forth in the KETRA notice, Notice 2005-92. So there's some specific examples you can look at there that should help you in figuring out how you might calculate that if the need arises. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.